Well, good morning, everyone. I hope you had a good day yesterday. Once again, there was lots of interesting and thought-provoking sessions and lots of Commonwealth conversations in between. This is our last full day, but there's still plenty of content to come and plenty of time to enjoy my home city of Glasgow. Today we have a packed programme again, both in here, in the Lomond Room and in the other bases. And after the keynote address, I'll tell you about a couple of bits of housekeeping regarding that. And for those of you attending tonight, the gala dinner at Kelvin Grove Museum and Art Gallery promises to be quite an experience of Scottish culture and cuisine to get your toes tapping and taste buds tingling. I managed to say that at 9:10 in the morning. Now to our third day of business, beginning with our keynote speaker address. This morning I'm delighted and honoured to welcome Dame Silvia Cartwright from New Zealand. Dame Silvia qualified as a lawyer and after 10 years in private practice became a judge, eventually becoming the first female chief judge in the district courts and then a high court judge. Dame Silvia has held many important roles, from appointment as a Khmer Rouge trial judge, which is the first time I've met one of those, to being a member of the New Zealand Commission for the Future and working with the United Nations to monitor elimination of discrimination against women. She was made a Dame Commander of the British Empire in 1989, followed by other honours, and again, a fuller biographical note in your programme. Dame Silvia, over to you.
Thank you. Well, this year marks an important anniversary in the development of law. So, 800 years too late, I extend my congratulations and admiration to those who encouraged King John to sign the Great Charter, Magna Carta. The risks to the nobles who confronted King John were enormous. There was a strong chance that they would end up dead or dispossessed, while the king became even more powerful and autocratic. Unfortunately, the barons were not thinking, we really must improve the way in which disputes are resolved, or how can we make the justice system less cumbersome and more accessible to the poor? As is so often the case, they were motivated in part by self-interest, as well as a determination to reign in an incompetent and venal monarch. They were resolving a local problem which was affecting their pockets and their security. They could never have envisaged that their actions would have a centuries-long and far-reaching impact on the rule of law and on the powers of leaders. In an obscure corner of Asia, over 700 years after King John reluctantly signed the Magna Carta, the equally venal leader, Pol Pot, with the help of his fellow tyrants, took over the country of Cambodia, closed its borders, enslaved and starved its people, and killed anyone who might be inclined to challenge their extreme version of Marxism. In the end, it was not the reassertion of the rule of law that ended the Cambodians' suffering. It was the intervention of their traditional enemy, the Vietnamese, whose security was threatened by Pol Pot. The Vietnamese invaders, or liberators, depending on your point of view, possibly also hoped that by annexing Cambodia, they might revive their dream of an Indo-Chinese federation led by them. In any event, tired of the ineptitude of the Cambodian leaders, they invaded and forced the tyrants to retreat. Well, it took another 30 years before trials for the Khmer Rouge atrocities could be contemplated, and for a fuller story of a nightmare lasting 3 years, 8 months, and 20 days to emerge. As a small, sad nod to history, in 2 days' time, it will be 40 years since the Vietnamese took control of the capital and drove the Khmer Rouge back to the west of the country, from where they continued to wage an ongoing civil war against the conquerors for another 20 years. In the last century, wars without borders have proliferated, and seemingly irrational leaders continue to commit savage crimes to retain wealth and power. In parallel, the United Nations has developed humanitarian law and practices to deal with massive offending against civilians. All manner of solutions have resulted, from establishment and support of vast refugee camps as internal and external migrations forced by war have expanded, to peacekeeping forces sent to regions where there is a chance, albeit small, of protecting and encouraging peaceful solutions to ethnic, economic, religious, and other conflicts. The international community has also responded by devising and refining legal definitions to deal with violations of criminal and humanitarian law and human rights norms and conventions. There's been plenty to work on. The Second World War, Rwanda, Yugoslavia, Sierra Leone, Cambodia. Inevitably, further revisions will occur if and when the leaders now provoking other unimaginably ruthless massacres in the Middle East and in less publicized conflicts in other parts of the world are brought to account. While we have not contained the crimes by the rule of law, we have efficiently categorized them into awful, worse, and horrifying. Perhaps the most important international criminal law category we have strengthened in the last century is that encompassed by crimes against humanity. As far back as the 17th century, Hugo Grotius, in a nice reflection of the disputes between the nobles and King John, enunciated the rights and obligations of kings and those who held similar powers. Not only could they try those who offended against them, but the rules were to be applied to the leaders themselves when they committed serious crimes against their subjects. But it was not until the early 20th century that the term crimes against humanity first appeared in a declaration by France, Great Britain, and Russia deploring the Turkish massacres of Armenians. Trials involving later conflicts have all discussed and expanded this category of international criminal law. Its underlying offences are very broad. They include murder, extermination, enslavement, deportation, imprisonment, torture, persecution on political, racial, or religious grounds, rape, and other inhumane acts which can incorporate offences such as forced transfers and forced marriages. At first, the acts comprising crimes against humanity had to be committed in the context of an armed conflict. Since the ambiguities of the conflicts in Rwanda and Yugoslavia, however, that artificial distinction has been diluted. Nevertheless, in the eyes of the general public, genocide is the star of international crimes, and there are demands that these charges be laid, even where other offences, such as crimes against humanity, may be much more appropriate. To prove genocide, there must have been acts of killing committed with intent to destroy, partly or wholly, a national, ethnic, racial, or religious group. The term genocide, however, is used to refer colloquially to a much broader range of egregious criminal acts. Unless we charge a contemporary tyrant with genocide, victims of international crimes committed on a vast scale seem to feel that their suffering is somehow belittled. Take the instance of the crimes committed in Cambodia in the 1970s and still being tried in that country. Out of a population of an estimated 7 million people, approximately 1/4 died by means of murder, starvation, slavery, or untreated disease during the almost 4 years of Khmer Rouge rule. The first major trial focused on crimes against humanity. Genocide trials, in which it's alleged that two minority groups, the Cham Muslim community and the Vietnamese, may have been targeted for nationality, ethnicity, race, or religion, are only now getting underway. The genocide allegations are, of course, extremely serious, with estimates of deaths in the small Cham Muslim population of around 36%, while virtually the entire Vietnamese population still living in Cambodia at that time died. Nonetheless, a vastly greater number, including those two minorities, was affected by the offences in the category of crimes against humanity. In the first few weeks of the Khmer Rouge regime, their army forced about 2 million people out of the capital city, Phnom Penh, and hundreds of thousands out of other towns and cities, to fulfill a Marxist dream of rural self-sufficiency. This was meant to lead to the elimination of cities with their supposed corruption and Western influences. There was no distinction made on the grounds of race, age, religion, or class. Everyone in the city was evacuated and forced to move on foot to a rural area. In Phnom Penh, after about 3 days of Khmer Rouge rule, that left only the Khmer Rouge military and a large number of foreigners imprisoned in the French embassy who were soon to be dispatched back to their own countries. During the weeks that ensued, vast numbers died, succumbing to heat, lack of water and food, and an inability to get medication or medical treatment. There was no specific intent to kill a particular ethnic, national, religious, or racial group. Rather, there was a total indifference to the inevitability of widespread death and suffering as Pol Pot pursued an ideological dream. People of a class expected to oppose the new regime, such as the educated, including the likes of the people in this audience today, and those who had worked for the deposed rulers, were killed in very large numbers. It was largely a political or ideological slaughter. Yet even those who survived this barbaric treatment seemed dissatisfied with the label crimes against humanity, lobbying instead for trials encompassing the real crime of genocide, often calling the court the Genocide Tribunal. A professor of human rights law, William Schaber, has written, "The category of crimes against humanity covers an immensely broader spectrum of atrocities than genocide." He argues also that the legal consequences of each category of crime have diminished. The International Criminal Court has the jurisdiction to prosecute crimes against humanity as well as genocide, and ad hoc tribunals have also conducted trials of both categories of offending. The maximum sentences are the same, and in effect, the fundamental reason for adopting the Genocide Convention, which was originally to formulate a crime that need not be linked to an armed conflict and could be prosecuted in peace as well as wartime, has now disappeared. Nevertheless, it is clear that the term genocide has entered the popular vernacular and has become the label du jour for all trials of mass crimes. The third major international criminal charge is that encompassed by grave breaches of the Geneva Conventions 1949 or war crimes. This category involves the commission, in the context of an international armed conflict, of one or more of a large number of acts or omissions against people or property protected under the conventions. Willful killing, torture, or inhumane treatment of prisoners of war are classic examples of proscribed behaviour. When war crimes are litigated before an international tribunal, the canvas is broad. Proof of an international armed conflict, which in earlier times was readily achieved, is now more difficult. Today's conflicts, even when they spill across borders or involve the capture of foreign military, will frequently lack the traditional trappings of a war. There may be no front line, no uniforms, no identifiable commanders with whom to negotiate, and certainly no concerns about breaching conventions devised in a simpler age. Well, there have been some modern developments since those three major categories of crimes were enunciated. And as way back in the 19th century, D. Vattel wrote, "If the prince attacking the fundamental laws gives his people a legitimate reason to resist him, if tyranny becomes so unbearable as to cause the nation to rise, any foreign power is entitled to help an oppressed people that has requested assistance." The modern reflection of that duty is a proposed norm, the responsibility to protect, trendily expressed as R2P, and it bears a discernible connection to the reasons that the nobles imposed limitations on King John when he failed to protect his subjects. While not yet having the status of international law, it's been widely debated and discussed since it was first mooted following the egregious attacks on civilian populations committed in the last decades of the 20th century. during which the international community seemed paralyzed. The norm was foreshadowed by the former UN Secretary-General Kofi Annan in his Millennium Report when he said, "If humanitarian intervention is indeed an unacceptable assault on sovereignty, how should we respond to a Rwanda or a Srebrenica, to gross and systematic violations of human rights that offend every precept of our common humanity?" While member states of the UN broadly support the responsibility to protect, it's a big shift for nations to concede that their domestic powers can be reviewed, or that international intervention might be a possibility should they fail to protect their people, or worse, actively oppress them. One scholar expresses the long-held right of states thus: "The Westphalian state-centric system of international relations has long privileged non-intervention. Inspired by the horrors of World War II, the UN Charter enshrined the equality of state sovereignty as the means to protect states from external aggression. While these norms have helped to ensure stability, they were also used to defend reprehensible behavior." And the Chinese international scholar, Professor Sheng Dingli, noted, "China has used tanks to kill people on Tiananmen Square, so it's Myanmar's sovereign right to kill their people too." At its foundation, the responsibility to protect asserts that sovereignty is not an absolute right. States forfeit aspects of their sovereignty when they fail to protect their populations from mass atrocity crimes. There are three main principles. A state has a responsibility to protect its population from genocide, war crimes, crimes against humanity, and ethnic cleansing. Secondly, the international community has a responsibility to assist the state to fulfill its primary responsibility. Thirdly, if the state manifestly fails to protect its citizens from the four above mass atrocities and peaceful measures have failed, the international community has the responsibility to intervene through coercive measures such as economic sanctions. Military intervention is considered the last resort, and the authority for that rests solely with the UN Secretary Council. Since the 1990s, the Security Council Charter, written primarily to prevent aggression by one nation against another, has authorized a variety of militarized missions in countries such as Somalia, Bosnia, and Afghanistan. But there remains a high degree of uncertainty as to whether the Security Council can act decisively in civil wars. Given the many failures, such as in Rwanda, Bosnia, and Somalia, and its inability to influence individual initiatives, such as the US-led invasion of Iraq, there is also great skepticism about the UN's effectiveness. It seems highly unlikely that sufficient unanimity could be achieved to invoke the developing responsibility to protect norm insofar as it relates to military action. But the codification of the increasing practices of imposing economic and other sanctions, the joint cooperative missions taken with interested nations and entities such as NATO, and peacekeeping missions have been advantageous. Moreover, the African Union, which adopted a very similar principle even earlier than the UN, agreed in 2000 that the Union had the right to intervene in a member state in grave circumstances, namely war crimes, genocide, and crimes against humanity, through diplomatic and peaceful measures, and as a last resort by the use of force. So there is the norm developing in a regional context. The responsibility to protect is an interesting addition to the armour of the international community, allowing for UN or regional intervention while a conflict is still occurring. There is real potential for immediate reaction should the world or affected regions react quickly and more or less unanimously to a growing crisis. But there are, of course, considerable problems, among which are which states have sufficient interest to intervene, and which will intervene simply on humanitarian grounds, and what happens when a state fails to protect its own and there is no unanimity enabling the UN or a regional group to act. The obstacles to intervention and peacekeeping remain such that we are still, as one writer has said, taking responsibility after failing to protect. After a conflict has settled, at least temporarily, there is often a call for a course of action akin to the Truth and Reconciliation process in South Africa. It's my view that while this process has many advantages, it has as many limitations as a trial of mass crimes. For example, it will normally cover only the smaller players rather than the leaders who are responsible for the conflict. Its major value is in providing a venue within which many victims have some chance of finding out from the immediate perpetrators what happened to their family members or friends. Senior leaders who do not dirty their hands during a conflict are unlikely to be able to shed any light on this. Nor does a truth and reconciliation procedure add to the international jurisprudence. While very much an objective secondary to seeking justice and reconciliation for the victims, it's important that a country's jurisprudence be able to develop, particularly as that country may be expected to hold ongoing trials of lower functionaries over the years. I see a truth and reconciliation process as one tool in reinforcing peace in a country, but it does little to avoid impunity and to call those most responsible to account. Therefore, it's likely that trials will continue, particularly as the international community is so much better at responding after the event. One of the arguments against holding trials is the enormous sums expended conducting international criminal trials, money which some say might be better applied to the redevelopment of the conflict-affected country. There is, however, an equally strong argument for upholding the rule of law and for ensuring that there are limitations on impunity. My dream while conducting trials in Cambodia, that somewhere a violent despot might see a clip on television and think more carefully about his actions, lest he face a trial at some time in the future. There is a certain power in the image of formerly formidable and terrifying leaders being held to account in a courtroom. Countries wishing to hold trials have many differing motivations. There may be international pressure or victorious new leaders who wish to demonstrate that impunity will not be tolerated, particularly where there are former rivals to try. There are a number of options. First, and on the face of it, the most desirable is the domestic trial. This assumes a relatively intact legal system, an adequate number of surviving judges and lawyers, and an institutional determination to hold fair, impartial, and expeditious trials. A second option is the domestic trial with international support, be that technical, financial, or by the provision of judges and lawyers to assist the local profession. The last option is the fully international trial, most likely now to take place before the International Criminal Court. Well, my personal experience is limited to a domestic trial with international support, as established in Cambodia, with the assistance of the UN. Every court, every discrete trial, whichever system is selected, will have a different history and many common problems, usually called challenges by the diplomatic community. Equally, there will be a multitude of issues that are unique to each trial. From the beginning, the character of the court will begin to emerge. Frequently, preliminary negotiations are marked more by political than legal considerations. There may be many meetings between the country's leaders and the legal profession, the international community and the United Nations or regional group. Inevitably, there will be pressure from non-governmental organizations, including those representing victims. When the law and procedures are settled, at least in principle, the venue decided, and preliminary funding in place, the diplomats will then retreat, leaving the lawyers, judges, and sometime the local governments to prepare for trials. Rules of procedure must then be negotiated and drafted, judges and lawyers appointed, premises found, translators, interpreters, and court staff recruited and trained. Well, I want to describe some of the experiences of a common law judge. The extraordinary chambers in the courts of Cambodia, known colloquially as the ECCC, was established after something like 10 years of frustrating negotiations between the UN and the royal government of Cambodia. While the use of the word extraordinary was intended to denote that they held a singular place in the domestic court system, never was a court more aptly named. The Cambodian trials are conducted in the French model of the civil law system, modified to some extent by common law procedures. There were many surprises for a common law judge, particularly one from the other side of the world with no previous exposure to the European courts. The first was the absence of an overt mechanism for a plea of guilty. It is the judge's responsibility to decide whether the evidence supports a conviction. In domestic courts, this is not an issue, but in Cambodia, where the first accused, Doik, at the outset accepted the major allegations against him and then focused primarily on the issue of mitigation, a 9-month trial still ensued, at the end of which he was still found guilty, as he had indicated on the first day. There were also issues with the practice agreed between the Cambodian government and the UN that national lawyers be assisted where appropriate by experienced international counsel. On a surreal final hearing day in Doik's trial, it culminated in his 2 lawyers, one Cambodian and one French, disagreeing on what outcome they sought from the trial chamber. And bear in mind, this is after 9 months of trial. The Cambodian defence lawyer submitted that Doik was not one of those most senior or most responsible and should therefore be acquitted, while his French counterpart argued that, of course, Doik was guilty, but that the sentence should be as modest as possible, given that he had cooperated and that there were a large number of mitigating features. I suspect it is the first time in a criminal trial that an accused has been asked to choose which submission he prefers. The integration of character evidence directed towards sentence as part of the actual trial was another practice that I found difficult to accept. My civil law colleagues grew tired of me asking why a trial judge would waste time hearing mitigation evidence when an accused might be acquitted, and tended to be dismissive of what they termed the bifurcated common law trial. The parallel work of all the main players also caused me some anxiety. For example, the investigating judge sets out all his findings of fact in support of the indictment and produces an extensive closing order which, in the pure system, cannot be amended by the trial judges. I found it really difficult to decide how much weight to give to his findings of fact if I was to try the accused. Then we called and heard many of the same and additional witnesses, although their statements had already been taken under oath and assessed by the investigating judge. There was, however, in the end, a reason for diverting from the usual civil law process. Due to time constraints, the investigating judges had not followed the normal civil law procedure of allowing defence or victims' counsel to challenge the evidence during the investigation, making it essential to rectify this omission at trial stage. Moreover, as the investigation is completely confidential, had the trial consisted of the more usual truncated assessment of the material on the case file at trial stage, the public would have heard very little evidence indeed. Only those motivated and literate, and there's a high proportion of illiterate people in Cambodia, would have been able to read the 740-page closing order. As a result, none of the 3 Cambodian judges and 2 international judges wish to follow closely the usual model of judicial assessment of the closing order at trial, which includes very brief interventions by counsel and then a verdict. The ECCC prosecutor's role is also significantly less important under the civil law model. They file a preliminary submission, propose witnesses at both the investigation and trial stage, develop legal arguments, and have the right to appeal the verdict. However, they have no direct control over the indictment or closing order, except the right of appeal of the investigating judge's determination, nor do they select witnesses, brief, and call them at trial. Until the rules were amended this year, they had no power to seek an amendment of the indictment. The judges, in fact, decide which witnesses to call and what order they are to be called from lists provided by the parties, leading to frequent argument from the parties as to the importance of certain witnesses and experts. Questioning is led by the judges, which involves hours of preparation, and there then ensued a blend of civil and common law procedures, with some examination in chief and some cross-examination by counsel for all parties, the prosecution, the defence, and the victims. Everyone reads the entire case file before the trial starts, and all lawyers, so the judges and all the lawyers each undertake the same tasks of evaluation of witnesses and evidence, reading witness statements and other material, and preparing questions. The duplication of work is one issue that could well be streamlined should there be future civil law-dominated trials. In the civil law system as practiced in the ECCC, the accused is not finally convicted or acquitted until appeal rights have been exhausted. This means the possibility of a retrial, partially or fully, before the appellate chamber. So that means a hearing of witnesses at investigation, trial stage, and before the appellate chamber. Legal arguments can be aired before the investigating judges, before the pre-trial chamber, which resolves disputes arising at the investigation stage, then at the trial chamber, only to be settled finally by the Supreme Court. Resources and certainty are the casualties of this process. Now, I'm not suggesting that the civil law procedure is less suited to trials of mass crimes than the common law. Both have their real challenges in dealing with a vast amount of evidence and material. For example, in the second Cambodian trial that I sat on, involving 4 very elderly accused, the parties proposed over 1,000 witnesses and experts and proffered more than 7,600 documents, including whole books and films. Even at a clipping pace of half a working day per witness, this is more than 2 years of evidence alone, not allowing for any legal submissions, the illness of the accused, which was quite frequent, holidays, and in the case of Cambodia, strikes by staff members who were not being paid. In other tribunals, including the ICC, there's been a gradual blending of common law and civil law processes. Whichever system is appropriate, however, there must be clear-eyed, early discussion of the procedures. In the Cambodian instance, while the civil law model generally worked pretty well, it required constant review as problems arose and seemed sometimes lacking in boundaries. For instance, where evidence is allowed in and then the judges decide on its admissibility, issuing a decision at the same time as the verdict. In the common law system, of course, the same problems would arise, but the extent of the evidence would have been determined pre-trial, which of course also takes time while argument is heard and rulings given. My greatest concern is the time taken for the full judge-led investigation before trial. While this provided an enormous amount of evidential material, the pre-trial period might have been better deployed using professional investigators guided by experienced prosecutors and producing a simpler indictment which could be amended by the trial judges if necessary. In my view, it is not useful to have pre-trial assessment of evidence. I remain persuaded that the common law approach is marginally the better option. All parties should have full pre-trial disclosure, a mechanism for pre-trial rulings on evidence, with the prosecutors taking responsibility for leading the evidence at trial, leaving the judges free to weigh and assess the evidence, control the number of witnesses, and hear full and robust in-court examination. Clearly, whatever the system, a judge-led trial can be more expensive than a jury-based process. It's unnecessary to retain strict evidentiary rules developed for trials with juries. An appeal should be limited to points of law with an opportunity to argue a miscarriage of justice. The time taken in relitigation of legal points on 3 or 4 occasions is unnecessary. Well, there were aspects of the civil law model that I much preferred, particularly where the judge selects experts, relying usually on proposals by the parties. This resulted in greater professional independence and reduced the spectacle of the clash of opinion, which sadly often appears to depend on which party has briefed the expert. There are a couple of matters I would like to focus on. One is the trial venue. It's not been common for international criminal trials to be held in the country in which the events occurred. Many international criminal trials are held in The Hague, where the efficiency of established courtrooms, the ready availability of experienced counsel, judges, investigators, victims' representatives, and concerned NGOs render this a safe decision. Often this will also provide a safer environment for witnesses. A disadvantage of in-country trials is the prospect of real or imagined local political interference and alleged corruption, both a constant and troubling issue while the Cambodian trials continue. An important advantage, however, of holding the trials in Cambodia has been the involvement of the public. Each day, up to 500 people file into the public gallery, and thousands more watch from screens in the cities and villages. The United Kingdom government funded an excellent television program of evidential highlights and explanation of the legal issues arising. Huge numbers of victims were encouraged to attend, often being transported from rural areas and also having the opportunity to visit Tuol Sleng, one of the most notorious of the more than 190 prisons operating during Khmer Rouge regime. Not uncommonly, many of those people identified photographs of relations or friends who had died at Tuol Sleng prison, and for the first time were able to understand where they had been taken and what had happened to them. Many of those in the public area were Cambodian students and judges, as well as a wide variety of local and international NGOs. In a country such as Cambodia, where the legal system is weak, an internationalized trial provides a useful opportunity to see how a so-called normal trial is conducted. All in all, by the time the first trial had ended, Cambodian support for the trials had risen significantly. In an ideal world, venue decisions would be made which focus on the exigencies of the trials rather than perceived political advantages of holding the trial in country. It will be an individual decision. Should the country completely lack independent judges and lawyers, and should, like Cambodia, there be very few senior judges who are actually legally trained, if there is a real concern over corruption and political interference, then either the trial should be held in The Hague or strong measures put in place to protect the integrity of the process. My personal view is that, where possible, it's preferable for the people of the country to see international justice occurring, to be able to participate without having to be torn from their homes and their livelihoods, the latter being particularly important in a country like Cambodia, where poverty is the norm. Perhaps the most important early issue to be negotiated is the role of victims and the prospect of reparations for them. The ICC claims to be the first international court to place victims at its centre. Well, I don't want to quibble with that, but the extraordinary chambers in Cambodia gives victims a pivotal role. Operating under the civil law system, the court created rules that confer equal party status on the prosecution, defence, and victims, who therefore have access to all stages of the investigation and trial, the right to call witnesses, and to legal representation. I very much support the civil law model where victims are central to the trial process. The model nonetheless requires careful review, particularly in trials of mass crimes. Some of the issues that caused ongoing difficulty included the following. First, reparations. In the Cambodian trials, there was no fund to provide any sort of financial compensation, and reparations were limited to the symbolic and moral. Unsurprisingly, this was a contentious issue for victims, not to mention a puzzle for judges to determine exactly what moral reparations might comprise. Even had there been provision for financial reparation, the issue of who to compensate when approximately 1/4 of the population had died, leaving millions traumatised, living in poverty and dispossessed of their property, poses a major problem. In a country where corruption is widespread, administration of compensation after the UN or regional body has left would be nothing short of a nightmare. Then there is the sheer number of victims seeking to participate. In Cambodia, this precluded individual representation, which is the norm in the domestic criminal trial. In the first trial, there were a mere 93 victims seeking to participate, but in the second, 4,000. And as a result, individual representation was completely impossible. It would have slowed proceedings to the point where they became unmanageable logistically and financially. Then there is the question of whether the person is a victim or a perpetrator. In a regime where who lived and who died was completely unpredictable, survivors included both victims and perpetrators, with a proportion clearly falling into both categories. For example, many Cambodians were given no choice about their role once the iron grip of the Khmer Rouge became a reality. So there were military guards who saw their relations killed by the regime, executioners who lost their own family members, children who were schooled to report on their parents and saw them led away to die, men and women forced to marry each other even when they had never met before. In this context, the crime of rape and who precisely was the victim is almost insoluble. Given the blurring of the victim-perpetrator role, which will occur in many trials of mass crimes, access to the confidential file while the investigation is underway could give rise to witness tampering, including intimidation, and give rise to difficult decisions over compensation, if any is to be had. Questions of trial management were particularly acute when it came to the victims, management of the victim's role. So we devised solutions such as combining all victims into a consolidated group represented by co-lead lawyers. This was met with trenchant criticism because each victim wanted his or her own individual representation. But there seemed no other realistic way to hold an expeditious trial. In court, while it is the responsibility of the victims known as civil parties to support the prosecution, there were a number of instances where the two parties were in opposition to each other. These and many other victim-related process issues took an inordinate amount of judicial time to resolve. If a similar situation arises where there are thousands of victims wishing to participate directly at trial, my proposal is to ensure that victims are grouped at least into interest groups, as the ICC has done, that the groups have excellent legal representation, privileged status, with the right to be heard and to call witnesses, at least at the sentencing stage, but no personal access to the case files while allegations are being investigated. Experience since the Nuremberg trials in the middle of the 20th century has made it clear that few nations are capable of conducting domestic trials of mass crimes committed during times of conflict. Where the aftermath of the conflict has prevented local trials being conducted in a timely manner, they may even become statute-barred under domestic legislation. Moreover, in a post-conflict society, the inadequacy of resources to conduct trials to the standard required and the scale and enormity of the offending all lead to a conclusion that the international community has a responsibility to offer assistance. There's a certain glamour attached to war crimes trials, one that I no longer find viable after 8 years in Cambodia. And that's due, no doubt, to films such as Judgment at Nuremberg, but the reality is always rather less alluring. After the Second World War ended, at least one victorious nation advocated that the German leaders should simply be hung, avoiding the cost and inconvenience of a trial which would inevitably find them guilty anyway. The fact that some were acquitted, others found not guilty of some of the crimes alleged, and that sentences were calibrated according to the degree of culpability, demonstrates that there was a preponderance of influential and cool legal and judicial heads, something that might not always be possible in a trial conducted by domestic judges. There are, of course, also many dangers for trials, regardless of whether they are conducted by a domestic or a wholly or partially international tribunal. The first and very real and not unrealistic risk is that fairly or otherwise, some trials will be categorized as victor's justice. Since Nuremberg, trials have tended to be more neutral, albeit accompanied by a high degree of political debate. Yugoslav, Rwanda and Sierra Leone trials have rightly been perceived as mainly successful in bringing to account the most notorious of the leaders responsible for the atrocities committed during the periods of internal conflict. Time is yet to tell if the Cambodian trials will be viewed in a similar light. More importantly, at least for lawyers, there has been a steady development of international jurisprudence, which, while not binding on later tribunals such as the ECCC, is at least persuasive and often extremely helpful. While positive for the development of the law, there remain innumerable problems associated with such tribunals, including the ICC. And I'll focus on only two of those. The first is cost. Where egregious criminal acts have been committed, the world community is often sufficiently shocked to commit funding to establish trials. At first, the member states of the UN agreed that funding for the Yugoslav trials should come from the general UN budget. Well, that attitude quickly changed when it became clear what the actual cost of establishing and running a court would be. Later trials, such as those in Sierra Leone and Cambodia, were to be funded by donor countries of the United Nations. Well, many promises were made at the outset when the donors, represented by diplomats, decided that the trials would take approximately 3 years. In fact, it took a year to settle the rules of procedure alone, followed by a 3-year investigation before the first trial began. The promise of money, however, like that for aid during massive humanitarian catastrophes, is often overcome by domestic imperatives or international events such as the global financial crisis. As a result, the money is often very difficult to extract, and when trials take, as inevitably they will, 2 or 3 times longer than the original unrealistic, optimistic estimate, enthusiasm for funding wanes. One of the major costs of trials is the provision of more than one official language. Interpretation and translation is very costly. Bear in mind those 7,600 documents, including whole books. It takes time to train personnel to the required standard and delays every part of the process. The agreement between the UN and the government of Cambodia required that the court operate in 3 languages, Khmer, English, and French, which had been the official language while the French colony subsisted down to 1963. Well, there will often be a need for more than one language, But those who conduct the negotiations before the trial is established must ensure that the absolute minimum is agreed and that enough competent translators are on hand. I have no immediate solutions concerning funding to offer, except to suggest that there be much more informed discussion prior to the beginning of the trials, so that unrealistic time estimates are avoided. I'd very much like to see hard-headed negotiations on the rules of procedure, led by pragmatic, experienced lawyers and judges, to eliminate time-wasting procedures, and as I have already proposed, to limit severely the number of languages to be used. While it is a fact that member states may insist on their procedures and their languages being used and promise to meet the cost, only if the funds are actually in the bank should such promises be relied on. As to the quality of the work undertaken in trials of mass crimes, there should be an equal emphasis before they start on the experience and reputation of the lawyers and judges who are to be appointed. Not every member of my profession or of the legal profession is hard-working and experienced. A few are even nominated because they're not very well respected at home, and this would be a good way out for the domestic tribunals. Simply because they have participated in other international trials does not mean that they are the best available for the task at hand. Age, commitment, reputation in their domestic jurisdiction, and professionalism are also factors. Well, what of the future? The Commonwealth has a long and admirable history of introducing, refining, and educating its members about the importance of the rule of law. It's given vital assistance and advice in many parts of the Commonwealth, much of which has been gratefully received by emerging democracies. While it has many calls on its resources and expertise in the field of the rule of law, human rights and humanitarian law, it may find occasion during or after a conflict in one of its member states to help negotiate a peace settlement or develop a trial court. Quiet diplomacy, rather than the strident headline, is a feature of Commonwealth work. Therefore, there may well be a greater willingness to seek the advice and assistance of the Commonwealth or some of its members than from the broader international community represented by the UN. If there were to be such an opportunity, I hope that the Commonwealth countries would support and encourage such measures and help to find ways to assist the conflicted country, deploying strategic intervention using the principles of the responsibility to protect, and emphasising the pivotal importance of the rule of law in building and maintaining peace. If a domestic court is ultimately established in a conflict-affected Commonwealth country, it's my hope that our Commonwealth will help by applying the lessons and not repeating the mistakes from the many regional and internationally established models, to avoid at all costs repeating the mistakes that lead to extravagance, delay, impunity, and cynicism. Well, contrary to much of what I have spoken about, I remain an optimist at heart. The Times might suggest that we've not learned the lessons that lead to peace rather than war, and that many leaders have absolutely no intention of doing so. But we cannot give up the pursuit of peace and the achievement of the rule of law in all countries, and particularly in our Commonwealth countries. So I'm going to leave you with a blessing from the Māori people of Aotearoa, New Zealand. Kia hora te marino, kia whakapapa pounamu te moana, kia tere te karohi rohi. May peace be widespread. May the sea glisten like the green stone, and may the shimmer of summer dance forever across your pathway. Thank you.
Thank you very much, Silvia. We're a couple of minutes over time, but let's see if there's anybody who wants to ask a question or say something. Gentleman there, there's a microphone down here if you'd like to come down. I'm sure we can all just slurp our coffee more quickly if we take a few minutes to deal with this. If you can say what your name and where you come from as well, sir.
Thank you very much. My name is Evans Monari from Kenya. Dame Silvia Cartwright, what you have said this morning is true. As a defense counsel at the ICC, I support the sentiments that you've expressed this morning. I would have gone out to ask many questions about the ICC, but they are not here, and it's not the day for that. I would like to rush to the present and speak about 3 things that are happening in Africa, which the world seems to have ignored. And as this is the premier law society of the Commonwealth, it's only important that these issues are brought out here. One is the disappearance of girls in northern Nigeria. The second is the recent killing of children at the universities in Kenya. The third is the ongoing maiming and lynching of foreigners in South Africa. My call upon this august organization is that do we leave Glasgow without a statement, without a position on these issues that affect the human rights of the people that are mentioned? That's all I wish to say.
Thank you very much. That may be something for the Commonwealth Lawyers Association more generally, but Dame Silvia, what are your thoughts?
Well, I completely endorse what Defence Counsel just said. These are the sort of outrages that the international community, and particularly the Commonwealth community, should be making clear are completely unacceptable. And even if, as a Commonwealth Law Association, we have no power to intervene, no powers to actually march in any more than the UN has to try and stop these things, these sorts of outrages, these tragedies will continue, and we must make our voices heard. Personally, while I'm a lawyer and a judge and I have spent my whole life conducting trials, that's very much shutting the door after the events are over. We have to put pressure of public opinion on the leaders who conduct these terrible, terrible events. So I would certainly support a statement. I know it seems weak, but at least it says we are concerned and that we want the international community to understand that.
Thank you very much. One final comment or question, or are we done? Yes, sir. Just like to come forward. Thank you. And again, if you say who you are and where you're from.
I am Aliyu Nasara Ibrahim from Nigeria. My question is, incidentally, I came from Kano, where in the northern Nigeria, where this Boko Haram problem is. The problem we have is, how can we effectively deal with the issue of weapons going into the hands of insurgents? Because most of these weapons we see are made from either the West or from the advanced countries. And they are from companies well known, and they are sold. But how do they get to the hands of these people? How do we manage, how can we control this? Because this is really a very big problem. I have not seen a significant mechanism of controlling these weapons going into the hands of the insurgents. Or maybe there is a legal solution to it, I don't know.
Well, you raise the most important point, and one which probably was laced through what I was saying. We're not good at controlling or even anticipating massive problems like this, and what the world community is good at is responding after the event in some instances. I can say things like strengthening the rule of law, but that means nothing to the Boko Haram and other similar bodies. What do they care about the rule of law? All we can do as lawyers and judges is to keep developing in a democratic system where the rule of law is respected and deal with the aftermath. I'm sorry, I wish there were a solution, but as I've already indicated, not even the UN has the power to intervene and stop an outrageous event such as have been happening at the hands of these people. And as I said in my speech, we don't even know who to negotiate with often. It's not like the good old-fashioned Second World War days where you knew exactly who the enemy was, identified by uniforms unless they were spies. So it is a much more difficult world. And if I were depressed, I would say we're going backwards rather than forwards. But as I said, I remain an optimist, at least I'm trying to be.
Thank you. Thank you very much, everybody. And thank you, Dame Silvia. Now, tomorrow's keynote speaker will be His Honour Michael Kirby, once again here in the Lomond Suite, in fact, at our closing ceremony. And shortly it will be time for our coffee break, but please be at your next business sessions on time. We'll try and catch up with time. And in respect of those business sessions, there's a slight change. There's a swap of venue for a couple of them, so I'll shout out what the 4 streams are and where they are, so keep careful note of that. Stream A, Corporate Commercial Law, is money laundering in the Commonwealth, big topic there. That's in the Alsh room. The Stream B, Constitutionalism, Human Rights and the Rule of Law, the question of intelligence, international intelligence sharing, that will be in here. So Stream B will be in here. Stream C is still in the Boysdale room, Legal and Judicial Profession, Global Legal Practice, How International is the Practice of Law in 2015. And Stream D in the Karen room, Contemporary Legal Topics, Cross-Border Cooperation between National Regulatory Authorities. So 4 very important and interesting streams there, and I'm sure you'll make your choices. So in the meantime, we'll finish this session by once again showing our appreciation for Dame Silvia Cartwright.